Listen closely, because what I'm about to share could genuinely change how you look at your mail, your phone calls, and the bills sitting quietly on your kitchen table. Every single week, I meet seniors who are doing what they've always done, the responsible thing, the honorable thing. They pay their bills on time, even when it hurts, even when it means cutting back on groceries or skipping a small pleasure they've earned. And yet, far too often, those payments were never legally required in the first place. Not because these seniors are careless, not because they made poor decisions, but because no one ever sat them down and said, "You actually have a choice here." I remember a conversation that still stays with me. Mr. Howard was 81, sharp mind, polite, apologized 3 times before even asking his question. He'd been paying a hospital bill every month for nearly 3 years. When I asked him why, he said, "Because they kept sending it, and I didn't want trouble." The truth was, that bill should never have been his responsibility. It had been denied incorrectly by insurance and then quietly pushed onto him, hoping he'd never challenge it. And that hope is what many companies rely on. Here's the uncomfortable truth. Many banks, collectors, service providers, and even medical systems quietly count on seniors not knowing their rights. They rely on fear. They rely on respect for authority. They rely on the fact that you grew up in a time when a bill meant a promise, and a promise was sacred. But the world has changed. Billing systems are automated, errors are common, and pressure tactics have replaced clear explanations. In that shift, too many seniors are overpaying, being misled, or carrying financial weight they no longer need to carry. I'm here today not just as a lawyer, but as someone who has spent years helping older clients untangle situations that never should have happened in the first place. This conversation isn't about avoiding responsibility. It's about understanding where responsibility actually ends. Over the next little while, I'm going to walk you through 6 types of bills that seniors are very often not legally required to pay. We'll talk about medical charges, old debts, confusing bank fees, insurance policies that quietly stop making sense, and a few situations that almost no one explains until it's too late. I'll share real stories, explain the protections the law already gives you, and show you simple, calm steps you can take to protect yourself. And at the end, I'll share one bill almost no one talks about, but one I believe every senior should double-check this week. It's quietly draining money from far too many households. So if you're a senior, or if you care about one, stay with me, and if something I say sounds familiar, you're not alone. Let's start with one of the most common and emotionally charged situations I see: medical bills. Medical bills arrive when you're already vulnerable. You're focused on your health, your recovery, or helping a spouse through something difficult. The paperwork comes later. Thick envelopes filled with codes, numbers, and language that feels deliberately hard to understand. Many seniors assume that if insurance denied a charge, the responsibility automatically falls on them. That's simply not true. I worked with a woman named Evelyn. She was 74 and lived alone. One afternoon, she opened her mail and saw a bill for nearly $4,800 from a hospital she barely remembered visiting. The insurance company had stamped it denied. Evelyn's first thought was panic. Her second thought was, "I'll have to figure out how to pay this." What she didn't know was that denied does not mean final. Insurance companies deny claims every day for technical reasons: missing codes, clerical errors, lack of prior authorization that was never requested by the provider. And in many of these cases, the patient is not legally responsible while an appeal is pending, or when the denial was caused by the provider's mistake. Evelyn paid the first installment before we spoke. When we reviewed the bill, we found the hospital had coded the procedure incorrectly. Once corrected, insurance covered nearly all of it. If she hadn't asked questions, she would have continued paying a bill she never owed. Hospitals don't always explain that you have the right to dispute, appeal, and request detailed itemized statements. They send the bill, and they wait. Silence often turns into payment. Now let's talk about old debts. This is one of the most misunderstood areas of the law, and one of the most aggressively abused. Debt collectors often reach out about credit cards, loans, or accounts that are many years old. They speak confidently. They imply urgency. Sometimes they even suggest legal action without saying it outright. Seniors hear phrases like final notice or last opportunity and feel cornered. I once spoke with a woman in her late 70s who had been paying $50 a month on a credit card she hadn't used since her husband passed away. The balance never seemed to go down. The truth? That debt was over a decade old. The legal time limit to sue had long expired. She could have stopped paying entirely. Every state has what's called a statute of limitations. After a certain number of years, a creditor loses the legal right to force payment through the courts. That doesn't mean they won't ask. It means they can't compel you. Here's the part collectors rarely explain. In some cases, even acknowledging or restarting payments can reset the clock. Seniors, acting in good faith, unknowingly give collectors new power simply by trying to do the right thing. Knowledge changes that dynamic completely. Now let's move into something that feels smaller, but adds up quietly over time. Bank fees. Monthly maintenance fees, overdraft charges, minimum balance penalties. Many seniors assume these fees are unavoidable. They've been with the same bank for decades. They trust it. They don't want to rock the boat. But many banks offer senior-specific accounts that eliminate these fees entirely. Others are required to refund fees that were triggered by system errors, delayed deposits, or improper posting of Social Security payments. I've seen seniors lose hundreds of dollars a year simply because no one told them to ask for a different account type. The fee isn't illegal, but charging it when a senior qualifies for an exemption often is. Silence benefits the bank. Questions benefit you. Now let's talk about insurance policies. This one requires honesty. Many seniors carry policies they no longer need. Life insurance meant to protect children who are now financially secure. Supplemental policies that overlap with Medicare coverage. Riders added decades ago that no longer serve their original purpose. I met a man named Carl, 79, who was paying over $300 a month for a policy he barely understood. He thought canceling it would cause penalties. It wouldn't have. He thought he'd lose benefits he no longer used. He hadn't reviewed the policy in over 20 years. Insurance companies don't call to suggest you downgrade. They don't send letters saying, "This no longer makes sense for your life." They simply continue billing. Reviewing a policy does not obligate you to keep it. Canceling coverage you no longer need is not irresponsible. It's practical. Now let's talk about bills that come from family situations. This is where emotion and law often collide. Seniors are sometimes pressured to pay debts belonging to a spouse, adult child, or relative. They're told it's expected. They're told it's necessary. Sometimes they're told it's the law. But unless you signed for the debt, guaranteed it, or live in a state with specific spousal responsibility laws, you are often not legally obligated to pay. I've sat with widows who were doing what they believed was expected of them. Month after month, they continued paying medical bills that were addressed to their late spouse. The envelopes kept coming, so they assumed the responsibility had quietly transferred to them. No one ever paused to explain that a bill arriving in the mail does not automatically create a legal obligation. No one told them they had the right to ask for proof. No one told them to look closely at whose name was actually on the account. Grief has a way of clouding everything. When you're mourning a partner, paperwork feels overwhelming. Many widows don't want conflict. They don't want phone calls. They don't want to relive hospital visits by asking questions. So they pay, hoping it will all just go away. What they often don't realize is that medical debt does not automatically become the responsibility of a surviving spouse, unless a document was signed, a guarantee was made, or specific state laws apply. Many of these bills remain tied solely to the person who received the care, but billing departments rarely explain this. They continue sending statements, knowing that silence and repetition often lead to payment. I remember one woman who paid for nearly 2 years before someone finally told her to ask a single question: "Can you show me where I agreed to be responsible for this?" They couldn't. The bill stopped. Just like that. Compassion does not require financial sacrifice beyond the law. Loving someone does not mean inheriting debts you never agreed to carry. Paying out of fear or guilt does not honor a relationship. Understanding your legal position does. And this leads to the thread that connects every story we've talked about. Fear is the most powerful billing tool that exists. Fear of court, even when no lawsuit is possible. Fear of collections, even when a debt can't legally be enforced. Fear of losing benefits, even when those benefits are protected by law. Fear of making a mistake, even when asking questions is the safest step you can take. Fear thrives in silence and confusion. It grows when letters are vague, when phone calls are rushed, and when people feel they're expected to comply without understanding. Companies don't have to threaten explicitly. They just need you to imagine consequences that may never happen. But fear loses its power the moment light is brought into the situation. when you ask for clarification, when you request written explanations, when you slow down and take control of the timeline. You are allowed to breathe before you pay. You are allowed to ask someone to explain something twice. You are allowed to protect yourself, even in moments of grief or vulnerability. The law does not punish you for being careful. It protects you for being informed. And once you understand that, fear no longer gets to decide for you. Most companies don't need to lie outright. In fact, many of them never do. They simply speak in a way that leaves room for fear to grow. They use broad language. They avoid specifics. They send notices that sound urgent but explain very little. And they rely on one powerful thing: your imagination filling in the gaps. When a letter says immediate action required but doesn't clearly explain what happens if you don't pay, most people imagine the worst: court, penalties, lost benefits, damage to their record. Companies understand this psychology very well. If they stay vague, they don't have to threaten. The pressure builds on its own. This is especially effective with seniors who were raised to respect institutions and follow instructions. When something looks official, it feels wrong to question it. So the assumption becomes, if I don't pay this right now, I'll be in trouble. That assumption is often exactly what they're counting on. But here's the truth, and it's important to hear it clearly. Asking questions is not refusal. It is not confrontation. It is not a red flag. It is your legal right. Requesting proof is not defiance. It is due diligence. Taking time to understand a bill is not wrongdoing. It is protection. No law requires you to pay something you do not understand. No rule says you must act immediately just because a letter tells you to. Deadlines printed on paper are often internal deadlines, not legal ones, and phone calls that create urgency rarely explain the full story. You have the right to written explanations. That means you can ask a company to clearly explain what the charge is for, why it exists, and why you are responsible for it. You have the right to verification. That means you can ask them to prove that the debt or charge is legitimate and belongs to you. And you absolutely have the right to pause before paying. Payment made under pressure is not required, and it is not expected by the law. Now, let me talk about a type of bill almost no one discusses openly, but one that quietly drains money from countless seniors every single month: utility add-ons and third-party charges. These are some of the most overlooked expenses because they're hidden in plain sight. They're buried inside bills you've been paying for years. Cable packages that include extra channels you never asked for. Streaming services bundled in without clear explanation. Phone plans that quietly add device protection or premium support for a monthly fee you don't remember agreeing to. Utility bills can be even more deceptive. Electricity, gas, or water statements that include third-party services such as maintenance plans, monitoring programs, or energy choice suppliers that charge higher rates than the default provider. These services often appear as a single line item with a name that sounds official, making it feel mandatory. Many seniors assume these charges are part of the core service. They believe removing them would disrupt their utilities or cause problems. In reality, these add-ons are optional. They are separate agreements layered on top of essential services, often activated during a brief phone call, a mailed offer, or even a checkbox that went unnoticed years ago. What makes these charges particularly harmful is how small they look individually. $5, $10, $15, amounts that don't feel worth arguing over, but over time, they add up, month after month, year after year, quietly pulling money from fixed incomes without ever announcing themselves. And here's the part most people don't realize. When these charges are questioned, many companies remove them immediately. No pushback, no debate, because they were never required in the first place. They existed only because no one asked. This is why clarity is power. The moment you slow down, ask for explanations, and separate what is essential from what is optional, the balance shifts back in your favor. You are not difficult for wanting to understand. You are not behind for needing things explained clearly, and you are certainly not wrong for protecting the money you worked your entire life to earn. Silence benefits the system. Questions protect you. These charges are often optional, but they're presented in a way that makes them feel unavoidable. They don't arrive loudly. They don't come with warnings. They slip in quietly, tucked into monthly statements that look familiar enough that most people never question them. Sometimes they're added during a phone call you barely remember, a quick conversation where you were trying to fix one problem, and somewhere near the end, a representative spoke quickly about additional protection or enhanced service. You might have said okay just to end the call, never realizing that one word turned into a monthly charge that followed you for years. Other times, these charges are bundled in so carefully that they don't look optional at all. A cable bill that slowly grows. A phone bill with a line item labeled so vaguely that it feels official. A utility statement that includes a third-party service you never personally signed up for. Many seniors assume that if it's printed on the bill, it must be required. They trust the system, they trust the company, and so they pay. What most people don't realize is that many of these add-ons are not essential services. They're not required by law. They're not tied to your base service. They exist because they generate profit when no one asks questions. And companies know that seniors, especially those who value peace and routine, are far less likely to call and challenge a charge that seems small on its own. But small charges have a way of stacking up quietly. $10 here, $15 there. Over a year, that's hundreds of dollars. Over several years, it becomes money that could have been used for healthcare, travel, gifts for grandchildren, or simply peace of mind. I've sat at kitchen tables with seniors and gone through statements line by line, slowly, calmly, no confrontation, no accusations, just awareness. And time after time, we've found charges that didn't belong there, services that were never requested, fees that were no longer applicable, add-ons that could be removed with a single phone call. And when those charges were questioned, something interesting happened. They disappeared. No argument, no legal battle, just quiet corrections, refunds, credits, relief. That's the power of understanding what you're paying for. And this brings me to the most important part of this conversation. Responsibility does not mean blind payment. Being responsible means being informed. It means knowing what you're agreeing to and what you're not. Honor does not mean silence. It does not mean accepting confusion just to avoid discomfort. Asking for clarification is not disrespectful. It is wise. Protecting yourself financially is not selfish. It's not stubborn. It's not ungrateful. It's an act of self-respect. You've spent a lifetime doing the right thing. You've earned the right to pause, to review, and to say, "Help me understand this." If there's one habit I wish every senior would adopt, it's this: slow down before you pay. Read the statement. Circle what doesn't make sense. Ask questions without apology, because the moment you stop assuming and start understanding, you take back control. You worked hard. You followed the rules. You deserve clarity. If a bill confuses you, pause. If a caller pressures you, slow down. If something doesn't feel right, trust that instinct. And please, share this message with someone who needs to hear it. A parent, a neighbor, a friend who apologizes before asking questions. Because sometimes, the most powerful thing a senior can do is simply say, "Let me understand this first. Thank you for staying with me." And remember, money is hard enough to earn. You shouldn't lose it to fear or silence.